Thank you. Hello, everyone, and thank you for joining us today. Welcome to the International Law Section's webinar on the war in Ukraine, legal and political implications for world order. We have 5 speakers today. Andrei Korbakov is professor of political science and international relations at Middle Tennessee State University and president of the post-communist states in IR section of ISA. Chip Carey is associate professor of international law and politics at Georgia State University. Most recent book is Legalization of International Law and Politics, Multi-Level Governance of Human Rights and Aggression, and he is chair of the International Law section of ISA. Henry Lovett is a lecturer in international law and politics at the University of Glasgow. George Andreopoulos is professor of political science at City University of New York. And Jennifer Davis is with the National Intelligence University. There will be time for questions after all the panelists speak. Panelists will be speaking for approximately 10 to 12 minutes. Please submit your questions through the chat function. I will aggregate them and they will be addressed in the order in which they are answered. We will try to get to every question. We will begin with Dr. Korbakov, and he will discuss the evolution of Vladimir Putin's views on Ukraine and its relationship with Russia in the last 20 years, as well as the changes in his justification of the invasion. Dr. Korbakov.
Thank you, Kitty. Well, first of all, I want to reiterate that Putin's views seems to have been changing during the time he was in the Kremlin. And when we talk about his views, we have to keep in mind, among others, that Putin has a legal education and he is trying to use both political and legal arguments in his reasoning. In general, in Russian political discourse, always present are both pro-Western views that right now referred to as the Atlanticist and those directed inside the country, emphasizing that Russia is a separate civilization and as such should not even try to join the West. These are the so-called Eurasianists. And while this is relatively new terminology, this divide goes back for centuries. One of the most controversial figures right now, and controversial not only because of his views, but also because of the different estimates of his influence on Putin personally, is Alexander Dugin, a very conservative thinker who was promoting these ideas of Eurasianism in recent decades. And I personally think that he has a very strong intellectual influence on Putin, although, again, I have to say that there are different views. Well, the shift towards Eurasianism started yet under Yeltsin in the mid-1990s. Essentially, the watershed here was more or less clear. It's the departure of Kozyrev as foreign minister and his replacement with Evgeny Primakov. And then after Putin came, after a transition period, he already started to formulate his new ideas. And the marker here is the Munich speech given in 2007, so it's been 16 years already, in which he basically emphasized his major idea, the Eurocentric system that has governed the world for centuries, is dying, and essentially we, Russia and the representatives of a number of other regional powers, have to do anything possible to speed up the process of its dying. Here is a quote from this speech. I consider that the unipolar model is not only unacceptable, but also impossible in today's world. And this is not only because if there was individual leadership in today's, and precisely in today's world, then the military, political, and economic resources would not suffice. He goes on and says, one state, and of course, first of foremost, the United States, has overstepped its natural borders in every way. He proceeds in his later speeches and publications to say that Russia has to take a leading role in this process, and it in general has a very positive importance meaning for the world. His second argument that he consistently uses is that Russia is not doing anything new in Ukraine. He says the precedent was created by the West through its operations, first in Belgrade and at the end of 1990s, then in Syria, Iraq, Libya, and therefore we're just following the model and the precedent that has been created. This is his vision. Besides that, the West has lost any moral or even legal foundations for its current claims, because it has consistently lied to Russian leaders, especially in regard to the NATO expansion. So this is kind of second claim that he makes. Third, and I think this is very important, Putin consistently, starting in 2014, denies the legitimacy both of the Ukrainian state and Ukrainian nation. He claims that Ukrainian nation is to a large extent an artificial construct that resulted from the separation of a group of subdivision of the greater Russian nation. And this process needs to be stopped. So for him, Ukrainians are kind of Russians with a speech defect. And in particular, he claims there may be an argument. If you are talking about a single large nation, a triune nation, then what difference does it make who people consider themselves to be? Russians, Ukrainians, or Belarusians? I completely agree with this. Especially since the determination of nationality, particularly in mixed families, is the right of every individual free to make his or her own choice. And this was emphasized again and again. In 2014, the thing is that Russians comprise 22% of Ukraine's population at the moment of dissolution in 1989. And besides that, a significant share of Ukrainians were primarily Russian speakers. And Putin, step by step, was increasing his emphasis on justification of invasion as a way to protect Russians and Russian speakers who were discriminated against in Ukraine. Well, the same argument goes in regard to the legitimacy of Ukrainian state. Putin claims that modern Ukraine has nothing to do with historical Ukraine, that it was created essentially by Stalin by adding both Russian-speaking regions in the east and regions that never were a part of Ukraine after the annexation of territory from, for example, Poland in 1939 and then again in 1945. And therefore, from this he derives that, well, there is not such a legitimate entity, legal entity as Ukrainian state. Special importance belongs to the Crimea, and it also lies at the center of his claims. Well, Crimea was annexed by Russian Empire in 1783. It was a part of first the empire, then the Soviet Union, part of the Russian Republic. And in 1954, Nikita Khrushchev, for some economic but primarily political reasons, it was a time of his power struggle with Malenkov. In 1954, he moves Crimea from the Russian to the Ukrainian jurisdiction within a single state. And there are two kind of arguments derived from that. First, it was an illegitimate action that took place within the authoritarian or even totalitarian state first. And second, and it's an interesting argument, he claims that Ukraine has got Crimea in 1991 as a result of a deal between Yeltsin, Kravchuk, and Shushkevich, the so-called Belovesia Forest Agreements. And he claims that it happened based on a goodwill on Russia, with the presumption that, Ukraine would retain good relations with Russia and more specifically would de facto remain its political and military ally. And therefore, to some extent, he is trying to use here such arguments as, for example, fundamental change of circumstances, and claims that because Ukraine did not fulfill its part of agreement, even if it was an oral agreement, Russia does not have any more obligations to respect territorial sovereignty of Ukraine, and more specifically, the fact of belonging of Crimea to Ukraine. So it's kind of, Ukraine has violated social contract. Here's two other arguments are referring to the politics within Ukraine. He claims that because, in his view, the Maidan was a de facto elite coup, the current government is illegitimate because everything that followed, including elections in 2014 and then in 2019, were illegitimate as well. And therefore, legitimate state Russia has to protect the regions that are right now under the power of the illegitimate government. His most typical argument, the one that he promotes all the time, and to some extent successfully for the Russian public, is that it's not a war of Russia against Ukraine. It's a war of proxy war of the West, of the US and NATO against Russia. And therefore, we see a pretty clear attempt to provide not only political but kind of legalistic basis for his actions starting in 2014. In general, what happened in 2014, not even in 2022, was taking place under very strong influence of events that preceded it in the previous 2 years. These were color revolutions in a number of countries. And then, protests at Bolotnaya Square in 2012 following Putin's election as president for the third term. He became totally, one can say obsessed with an idea that all these movements, including the events at Maidan in 2005 and then in 2014, were the result of activities of the CIA and the fifth column within those countries. So there was a visible change in his attitude, both to events outside Russia and the social movements within Russia. He started to pressure his own intelligence services to report to him about the involvement of special services in the West in the activities of such organizations. They popped up the idea of foreign agents. And in general, the policies towards opposition became much harsher. We see a new wave of this process now. But in general, one thing that I wanted to discuss and emphasize was this attempt to kind of provide not only political but also legal explanations for what Putin was and is doing in Ukraine. Thank you.
Dr. Korbakov, thank you very much. Our next speaker is Dr. Carey, and he will speak on jus ad bellum and associated accountability and issues. Dr. Carey?
Thank you, Kathy. The crime of aggression, sometimes referred to as jus ad bellum in Latin, is really the purpose of the war. And while vague and implicit over the centuries, in the 20th century, the Kellogg-Briand Pact was the explicit plan to outlaw war. It was arguably not legally binding and arguably not binding on Germany, which had pulled out of various international legal commitments, and that the prosecution of crimes against the peace at the Nuremberg International Military Tribunal at the end of World War II and thereafter was retrospective ex post facto justice and therefore illegal, as well as victor's justice and so forth on a number of other crimes. But the establishment of the idea of crimes against peace and its reinforcement and consolidation through various UN resolutions, sometimes referred to as the Nuremberg Principles, meant that the prohibition against war outside of self-defense and or outside of a UN Security Council authorization was illegal. To say that something is illegal is not to say it's necessarily criminal, and illegal acts take place all over the world. Most people speed in their cars from time to time, for example, and impunity generally is the norm for high-ranking officials on most issues most of the time, including in the developed world, including my country, the United States. Nevertheless, the law, by occasionally criminalizing or at least illegalizing, as it were, explicit attacks of one country against another, has not only had legal value in the sense of making the law more precise and implementing it against the high criminals at the first tribunal in Nuremberg, 1945 to 1946, it also created a movement towards the rule of law more generally for other associated crimes that my co-panelists will look at in this particular case of Ukraine. The Kellogg-Briand Pact was said to have started a process that Shapiro and Hathaway's book from a couple of years ago that led to Article 2.4 in the UN Charter, banning attacks of one state against another that violated the territorial integrity or the political independence or any other of the purposes, capital P, of the UN. Those three categories are quite significant in the politics of aggression that I'll mention briefly in passing. But as far as the law concerned, Shapiro and Hathaway also argue that the mere fact that it was explicitly made illegal to violate the territorial integrity of one country by an attack from another has, independent of other factors like nuclear deterrence, traditional deterrence, and other claims in the international system, has independently reduced the number of attacks. And it's quite striking how few international attacks to violate the country's borders occurred since the UN Charter. The vast majority of wars have been internal civil wars. It's not to say that those wars were not internationalized with support from outside, and that there wasn't some form of interference in the domestic affairs by taking sides, particularly by giving arms, but even other types of actions all the time. But an explicit attack of one country against another has been, I think, by conventional wisdom, an explicit success of the international liberal world order created by the UN Charter and other post-World War II institutions. When we look at this concept of aggression, we can say legally, it's still, except in that blatant case, like the attack of one country against another, imprecise. And in any legal conflict, whether an automobile accident around your house or anywhere else, there's often, not always, but often two sides to the story. And that's partly because of different interpretations of the law. So with the Russian attack against Ukraine, the conventional and overwhelming view, at least certainly in the West, and those who actively support this liberal world order that has been created since 1945, is that Russia acknowledged the boundaries of Ukraine in the peace treaty signed by, in effect, a peace treaty, but a treaty nonetheless, between Ukraine and Russia under Boris Yeltsin's leadership, to recognize the borders and the independent sovereign status of Ukraine, and largely in return for its giving up its nuclear weapons to Russia. And that act of recognition is the central argument that Russia explicitly has committed aggression and could be taken to court, the International Court of Justice as a state, and individual leaders like Putin at the International Criminal Court, or some kind of ad hoc tribunal created both under international or domestic auspices. Putin's recent indictment for a relatively minor crime, but one similar to the record of the ad hoc tribunals, deportation of children, is a little bit different from the child soldiers convictions that were rendered by many of these ad hoc tribunals, because it's so easy to, comparatively easy to argue the legal case. You catch the children on photographs and movies and videos, and that's prima facie, if not overwhelming evidence of complicity for a conviction of some sort. So we can say that using a political science concept of legalization with three criteria, the legal obligation to respect territorial boundaries is very high, and its meaning is relatively clear in the explicit case. Although I should note that recently President Lula of Brazil has said explicitly that NATO in the West is guilty of aggression in Ukraine for perpetuating the war by arming and continuing to arm Ukraine indefinitely with heavy munitions, and that the real culprit is the West, rather than acceding, apparently, at least implicitly, to Russia's territorial demands, which are based on Russia's view of a self-defense rationale. Russia's, this imprecision in the law comes about in part because the United States explicitly committed aggression in Iraq. And even the UN Secretary General Kofi Annan said as so explicitly not too long after a UN Security Council resolution to attempt to say that the US-led invasion among the coalition in 2003 was legal. That failed both in terms of failing to get a majority, and also the US was not able to prevent vetoes by great powers on the court, on the Security Council. So the third prong of the legalization concept is third-party resolution. And here we can say it is weak, and that it is weak because the presumptive adjudication and prosecution of the culprits in various fora that I mentioned a second ago seems to have no particular prospect, short of this war ending with a regime change in Russia and or an occupation. Most wars do not end in an explicit World War II type total victory and a demand for total surrender. So the only way it's likely, even remotely likely in this case in Ukraine, that Russia would cough up Putin is if Russia offered Putin up after a coup d'etat or some other regime change, or someone else that very high order in the country. And Putin and Russia could just simply refuse to take part in the International Court of Justice, and its current legal provisions don't allow for automatic jurisdiction of the ICJ there for any type of case. We've been, as I mentioned, in a liberal world order, another political science concept, the essence of the liberal world order, I would argue, has been this Article 2.4. And as I noted, Article 2.4 was shattered by the US in Iraq, but it was also violated in Afghanistan and Libya for changing the political independence of those two countries with intent in Afghanistan, and perhaps not with intent in Libya, but still it happened. So the case for an illegal violation of Article 2.4 by the United States is at least two, if not three, major precedents in the 2 decades of the 21st century, prior to the 2015 violation by Russia by annexing the Crimean Peninsula and starting an active war that has continued since then in the eastern regions of what is now generally referred to as the Donbass region, or at least the easternmost part of it. I should note there has been some minor degree of accountability. I wouldn't call it the third plank of the legalization trichotomy of third-party resolution of disputes, but this mild form of accountability has come in form of truth commissions that are and criminal investigations that are ongoing, led by the ICC itself, led by the government of Ukraine, and various other places. These have not really been published, and they've been focused on use in bello, but implicitly there's a use ad bellum, that is a violation of the territorial integrity of Ukraine, that will be included. Second, the unilateral sanctions on Russia, which were not approved by the Security Council and might be argued to be illegal themselves, nevertheless have frozen Ukraine's assets. And there's been much talk to use them to compensate Ukraine, at least especially for the attacks on civilian populations that are ongoing, and more generally, the start of the war. And again, the aggression is the fulcrum. Without the illegal attack on another country outside of any notion of individual or collective self-defense, is the crime of all crimes, in the sense that anything else that follows, from war crimes to crimes against humanity to genocide and other horrific atrocities, would not occur were it not for this initial act of aggression. And yet we have already the emergence of an articulation of a counter-aggression conceptualization by Lula and other countries remaining quiet in the most blatant of examples of a violation of aggression, leads us to think that worse is in store rather than a reinforcement of the liberal world order. I would point out, though, that all of these violations of international law, including attacks on other countries, have historical precedents, some of which were declared to be explicitly illegal, such as the invasion of Belgium in World War I as a neutral status country. And there was an attempt to bring King William into the dock, and most of the various prosecution attempts after World War I were a failure, but that only made the Kellogg-Briand Pact possible, which led to this long peace, as it were, at least from an international border viewpoint, from 1945 until the 21st century, roughly equivalent to the long peace in Europe after the Vienna meeting of the Congress of Vienna in early to late post-Napoleonic 19th century. The Kampala Conference in 2015 gave the Conference of Parties, created the crime of aggression as a prosecutable crime before the ICC. And so it's now the fourth core crime of the International Criminal Court. Again, they haven't had the flurry of both pre and post-conference meetings of parties to identify the elements of crime for the crime of aggression in a way beyond the very explicit understanding that sovereign borders are the essence of the crime of aggression.
Sure.
Will it include political independence or not remains to be seen. I'm out of time.
You're out of time.
Okay.
Thank you very much, Dr. Carey. We appreciate it. Our next speaker is Dr. Lovett. He will be talking about use in bello and the associated accountability issues and challenges. Dr. Lovett.
Thank you very much, Kathy, everybody. I have some slides which we can try and use if everybody agrees, or at least if nobody objects. I see Jen laughing and smiling, so I hope I'll take that as assent, and George is smiling, so that's always good. Right, let's see if we can get this to work. Wish us luck. Do we have?
We're on, and it looks good, Dr. Lovett.
I love the Dr. Lovett, Kathy. That is so kind. All right, so what I'm supposed to do in the next, I can't see my clock, next sort of 5 to 10 minutes, we'll try and be quick, is run through some of the key law of armed conflict issues that we've seen in the ongoing Ukraine conflict crisis. Now, I thought about how to do this, and it seems to me that the best way to proceed, because I know, Jen, you're going to talk about accountability more generally, would be to outline the starting points for a LOAC analysis, these things we're going to be, that LOAC draws attention to, and then flag some of the issues and difficulties with, let's say, operationalizing these in the Ukraine context. Chip, I was very struck by your references to Article 2.4. I think I can only commend the absolute the confidence with which you approach the relevant law there. LOAC is not always so clear. There's a lot more issues that are grey rather than black or white. And I hope that become clear as we move forward. So, what have we got? That's what we're going to cover: fundamentals, conflict classification, and then basic principles of some of the issues. What are the sources of law we talk about LOAC? Really, mostly we have in mind the Geneva Conventions, 1949, the two additional protocols of 77, and some other, let's say, odds and ends. Some people consider the Rome Statute to be part of LOAC, some don't. There are various weapons prohibition treaties, there are various specialized conventions, e.g. on militaries and what have you. But by and large, when we talk about LOAC, we mean, or most, I think, practitioners will mean the 4 Geneva Conventions and the 2 additional protocols of 77. A key issue in LOAC obviously is conflict classification. Are we talking here about a non-international armed conflict or an international armed conflict? Why does it matter? If we're talking about a NIAC, then the rules involved are very, very minimal. IAC, international conflict, we know involves a whole panoply of conventional elements, the various provisions that are in there. NIACs, non-international conflicts, are very different, much more minimally regulated, principally via common Article 3 of the Geneva Conventions. Now, common wisdom will say that what we're seeing here in Ukraine is predominant, is an IAC, international conflict. That indeed is certainly the case for most of the elements of the conflict. We are seeing Ukrainian forces fighting Russian forces and vice versa. But there are also elements, if one likes, of non-international conflict. We are seeing Ukrainian nationals in eastern, let's say, occupied or Russian annexed territories, also in combat with other Ukrainian forces. This could complicate matters slightly, but again, that's not so unusual to see different types of armed conflict, let's say, running alongside one another in the same context. So often when we draw the analysis, legal analysis will often depend on who are the combatants, what's the conduct in question, and what are the regimes and precise rules governing those. Taking a step back is worth bearing in mind here that we talk about LOAC. There are various advocacy actors, the ICRC, who are very keen to promote a uniform approach, to promote a uniformity of rules across all forms of armed conflicts. We will see that you see it come across in some of the international criminal jurisprudence as well, with Tadic and Cassisi's famous dictum around, what is prescribed in IAC must be also in NIAC, first to that effect. But technically, there's a bit more to it than that, for better or worse. But all that said, let's proceed on the basis that we're looking here at predominantly an international armed conflict. We then have three key principles which guide conduct, or supposed to guide conduct, in these situations in all armed conflicts. The precise, now why is it that lawyers talk about armed conflict will often talk in terms of these principles: distinction, precaution, and proportionality, because the alternative is to dive into a world of very, very precise and, to some degree, black and white, to some degree very uncertain drafting of precise principles. This is limited use, and arguably reflects the sort of classic approach of a treaty as a disagreement reduced to writing. So instead, let's take to a fairly high level here. Each of these principles is grounded in different elements of the key conventions, but by and large, we can, I think, reasonably, in sort of in classic Hillelian style, condense the whole of LOAC to more or less elements reflecting these three principles. So first principle, distinction. Absolutely critical distinction in LOAC between civilian objects and military objectives. This feeds into targeting decisions, it feeds into what weapons are used, and so on. There are a few issues worth flagging here in particular. The key distinction we talk about is military objectives versus civilian objectives, and civilians and personnel of the combat, HDC. The rule is, of course, that one must not intentionally target non-military objectives or civilians. That's fairly simple, but it can be more complicated than that. For example, civilians who are directly participating in hostilities, DPH, can legitimately be targeted. That then has implications in Ukraine, as we'll see in a little bit. Now, what that looks like, again, is subject to debate. The law is not clear in this area, but by and large, if an actor can make a credible claim that a civilian it has targeted has been directly participating in hostilities, that will justify, in terms of LOAC, that particular conduct. The same goes for essential infrastructure. Now, essential infrastructure, by and large, civilian infrastructure, there's water, power plants, so on, cannot be targeted. But again, there are qualifications. If there's if the fact is that these installations are being used principally, predominantly, solely for military purposes, the rules are slightly different. Installations containing dangerous forces have particular protection, and there again, we can think about nuclear power plants, dams, that sort of thing. And starvation and terror, mainly civilians, are of course forbidden means of conflict. Methods, I think, is the term there. Proportionality, now often misunderstood, but it's worth bearing in mind there that we're talking here about a balance in particular between, let's say, the anticipated military advantage of a particular course of action and the anticipated collateral damage. Now, the problem here is that we're talking really apples and oranges, right? These are both fruit, but of different natures. And so there is, I think it's fair to say, there is no settled consensus on how, despite the principle being widely accepted, it should actually be operationalized. Different states have different doctrines, but there's no simple equation. X civilian casualties are justified by Y military advantage, or different dimension types of things. This can be quite a difficult calculation to make, and is often determined by the commander in the field. Again, though, this goes to targeting decisions, it goes to means of conflict and methods of conflict, all the way through military conduct. And last, similarly, the obligation to take precautions in attack. And the term you see in the conventions is constant care. It's obligation that even through all stages of an attack, parties are obliged to take all feasible precautions in regards to means and methods to protect civilians. Now, that works both ways, right? So on the one hand, it means, yes, an attacker must take all feasible care not to target civilians and to watch proportionality. On the other hand, though, it also means places an obligation on the other party, the bending party, if you like, not to collocate military and civilian objects or populations. There's also a role to enable precautions to be taken. So again, often this can be difficult to translate into black and white in operational terms, right? There's one thing to sit here, but when you have an intermingled population, when you have civilian military infrastructure very much enmeshed, these can be very difficult obligations to operationalize. And in consequence, that can make it difficult, as I think Jen's really going to discuss, to actually make some of the associated accountability determinations clear. So how does all this translate into the Ukrainian context? We see a range of issues, but we're going to touch on a few here. There is a key obligation in LOEC is humane treatment of detainees and POWs. Information should be shared, whether you're a civilian or a POW, the rules are slightly different, but by and large, dignity, humane treatment, all that good stuff these are sort of, absolute obligations. And yet, we see executions, we see deportations, we see screening of civilian population to determine who's competent, who's not, who's been engaged in combat and who has not. Now, certain of these activities are going to be highly debatable under LOAC, like deportations, which might explain why the ICC prosecutor has chosen to go down that particular route with Putin's indictment. Others less so. Screening arguably makes sense as a measure to determine who is a competent, who is not. But then questions of how you carry that out. So arguably might say, yes, it is reasonable to detain civilians to determine whether they are in fact competent. It is less reasonable to inflict on them inhumane treatment. Again, and we're then to issues of that are perhaps less black and white. Targeting. If you remember, there was a long attack in the region of the Zaporizhia power station, nuclear power plant, during the conflict. At no point, interestingly, was it suggested that the nuclear power plant itself was being targeted, from what I'm aware. Rather, the issue seemed to be the networks around the power plant. Now, that's quite interesting because it really goes to this dual use key infrastructure containing dangerous forces point. The sense obtained, the sense being that these are quite carefully calibrated targeting decisions, right? Regardless of which side you think of the line they fall on, they're in that sort of gray penumbra. No one's saying we're going to drop a bomb on your local nuclear power plant. Mercenaries, now we talk often about the Wagner group and whatever. Mercenaries have no competent privilege. Fine, makes sense. But then who's a mercenary? And if you look at the relevant provisions, I forget what article of the International Protocols, and also separate mercenaries convention, we see that yes, Wagner would generally qualify, but for an attachment to the military forces of Russia and also being Russian citizens. So they would fall outside, strictly speaking, that definition. There are also broader issues around attributing third-party conduct to a state. What's the relevant test? Is one of overall control or effective control? Do you follow Nicaragua in the ICJ or the ICTY in Tadic? Again, the law here is not entirely clear, but one suspects that the better legal argument, the better position would be to say actually these Wagner fellows are really Russian combatants in a different guise. Urban warfare has its own challenges, not least information-wise, right? We have all the rules we like, for civilians, intermingled populations make this very difficult to operationalize, but even when the commands are trying to apply the rules directly, obtaining information in a sufficiently clear sense to determine what has actually happened can be quite challenging in these situations. Weapons, I'll finish with that one because it's quite interesting as well. Occupation, what is the status of the Donbass, of Eastern Ukraine, of Lugansk, Donetsk oblasts? A bit tricky. Russia claims to have annexed it. On the other hand, these could be occupied territories or occupied territories that's a regulated status. Query, is Russia comporting itself in compliance with its obligations under the relevant laws on occupation? Weapons, tech, and cyber are interesting as well. And the reasons that I find particularly interesting is there are actually hazards here for both sides. One of the really interesting features of this war has been the use of nominally civilian tech infrastructure, cameras, drones, what have you, to provide, thank you, Kathy, I see that I'm almost there, provide real-time intelligence for targeting purposes and what have you. But of course, that then begs the question of, well, okay, if you're providing targeting information, are you still a civilian? How does that work? And perhaps the better argument in these situations is that actually these nominal civilians providing that information are arguably DPH and therefore can legitimately be targeted as combatants. That opens up a whole other level of a whole set of issues, particularly the question of whether Ukraine has warned its own civilians that conducting these activities can incur that risk alongside. I'm going to stop there. That's a brief run through some of these issues. I hope you found it interesting.
Thank you, Dr. Lovett. I appreciate that. Our next speaker is Dr. Andropoulos, who will speak about contrasting perceptions between countries in the global north and the global south on the war in Ukraine and its legal implications, and on the status of the Wagner Group under IHL. Dr. Andropoulos.
Thank you, Kathy, and thank you all for being with us today. I'm going to address briefly a couple of issues, as Kathy has alluded. The first is the issue of how the conflict is perceived in different parts of the world and its implications for international law. And the second, I'm going to zero in on the Wagner Group and the issues, its status and accountability prospects under international humanitarian law. Well, starting with the first one, is the war of Ukraine a battle between democracy and autocracy? Well, that's what President Biden and a lot of other leaders in the States claim, and they have tried to frame a narrative as one of the ways to cement the unity of the West in this juncture. But this is not what many voices in the global South see. This was one of the voices that expressed reservations about that, was none other than the president of the World Health Organization, Tedros Ghebreyesus, who pointed that what this shows the reaction in the West, that the West does not give equal importance to the lives of Yemenis and Tigrayans compared with Ukrainians, for example, when it comes to their plight. And he added, some are obviously more equal than others. This is one of the reasons why many countries have abstained from resolutions on Ukraine at the UN General Assembly. And this is not only dictatorships that have done that also, but countries like Armenia, Brazil, India, Mexico, Senegal, and South Africa, among others. The cleavage between the West and the rest, so to speak, was also reflected in a poll, a recent poll that was conducted in late December 2022 and early January 2023 for the European Council on Foreign Relations, in which they poll a select group of individuals from 10 European countries: Denmark, Estonia, France, Germany, Great Britain, Italy, Poland, Portugal, Romania, and Spain, and 5 other countries outside Europe: China, India, Turkey, Russia, and the United States. The total sample included 19,765 people, and was a combination of an online survey and, in some cases, face-to-face surveys. the respondents to the poll were asked several questions. One of the questions, the most pertinent for what the point I want to make is, what do you think is the main reason the United States stands behind Ukraine? And the respondents were given 4 options. 1, to defend Ukraine's territorial integrity. 2nd, to defend Ukraine as a democracy. The 3rd, to defend Western dominance. And 4th, to defend their own, meaning the United States, security. The vast majority of the respondents from Chinese and Turkey, 65%, opted for the last 2, that this was all about defending Western dominance and the United States' own security. India was an exception from those survey in the sense that their sample was evenly split between the first 2, that is territorial integrity and democracy, and the last 2, Western dominance and the US security. Similar results to the question of the came to the main reason as to why Europe stands behind Ukraine. This poll also reaffirms the view that several major players in the non-Western world view America and Europe as part of a single West. 59% in Russia, 60% in China, and 72% in Turkey see very little difference between the US and the European Union policies towards their countries. This, of course, must come as a disappointing finding for Monsieur Emmanuel Macron, who tried to combat this impression in his recent trip to China. And as you know, this has generated quite an interesting discussion and controversy. Now, what are the implications of this for international law? There is a lot of talk in the global South about the West double standards and hypocrisy. And this has already been alluded by a couple of other speakers on this panel. You want, for example, talk about democracy and human rights, war crimes. What about the quest of peoples for self-determination? Well, the US has quite a remarkable record on that front, having bombed Serbia and Libya and having invaded Iraq. So that generates the question, is the US one of the countries that should be spearheading discussions about adherence to the norm governing the use of force and defend it as a supposedly key part of a rules-based international order? What about the use of cluster munition, phosphorus bomb, and depleted uranium projectiles in areas like Fallujah in Iraq, in Afghanistan in 2009, or in Syria and Iraq while fighting ISIS? Talking about war crimes, well, there are allegations that the US has committed a lot of war crimes in Afghanistan and Iraq. Is an investigation going on, let alone who is prosecuting? And if you want to talk about the norm of refugees, the differential reception that Ukrainian refugees have received from, let's say, Syrian or Tigrayan refugees, to bring back the earlier comment by the director of WHO. So these issues reinforce the tendencies in several countries in the global South to view Russia's aggression primarily through the prism of their own national interests rather than universal principles that are codified in international law, which are at stake and need to be defended at all costs. So this is an issue, actually, that the West should seriously think about, especially as the war drags on. Now, I'd like to switch gears, if I have a bit more time, to look at the status of the Wagner Group under the law of armed conflict. The Wagner Group, as you all know, is a private military and security company. It is estimated, according to reports that have seen, that has about, at the moment, 50,000 fighters in Ukraine. Out of them, again, according to press report, 40,000 are Russian convicts, and about 10,000 are contractors. Russian law, of course, does not authorize or recognize the activities of private military companies, but the Wagner Group has registered as a company in 2022 and has opened also a nice headquarters in St. Petersburg. It has been heavily, of course, involved in other places, not only in the Ukraine war. For example, they have been involved in Syria, in Libya, in the Central African Republic, in Sudan and Mali. But of course, the focus here is what is the situation with Ukraine. And it has been involved in the fighting and among other Russian efforts to capture the city of Bakhmut in eastern Ukraine. And there have been numerous allegations concerning violations of the laws of armed conflict committed by its troops. Allegations, of course, that include that some of its fighters have played a leading role in the massacres at Bucha. So, first of all, the Ukraine conflict is an international armed conflict. And both the Ukraine and Russian Federation have signed and ratified the Geneva Conventions and Additional Protocol 1, so they both apply. Now, the term mercenary is used very often to describe that group. And the first question I'd like to ask is, can actually the Wagner Group is classified as a mercenary group? Well, if you look at the relevant article here is Article 47 of Additional Protocol 1. And among the attributes of mercenaries is that the mercenary is neither a national of a party to the conflict, not a resident of a territory controlled by a party to the conflict. Now, although there are reports that indicate that Wagner's members include a range of other nationalities, like, for example, there are reports that they have been recruiting Armenians, have been recruiting people from Moldova, have been recruiting people from Poland, from Hungary, from Canada, and so on and so forth. The majority of the fighters in Ukraine are Russian convicts, and therefore they do not qualify as mercenaries. Those that might qualify for that title might be those that do not fulfill the attributes of Article 47, but and this is something that will need to be addressed on a case-by-case basis. But clearly, the majority of the fighters of the Wagner Group do not qualify as mercenaries under Additional Protocol 1. Now, are they armed forces to the conflict? Here, of course, Article 43 of Additional Protocol 1 comes into place, and what it provides that the armed forces part of the conflict consists of all armed forces, groups of units, who are under a command responsible to that party for the conduct of its subordinates. And in this case, of course, the question is to what extent, if we want to talk about attribution of the activities of the Wagner Group to Russia for issues of accountability in the context of state responsibility, not in the context of individual criminal responsibility, it seems that the standard that at least it can be arguably used is the one of effective control. The one actually that was laid out in the Nicaraguan, although there is also the alternative, the overall control standard, although as the commentary on Article 8 on the states, on the articles on draft articles on the responsibility of states of the International Law Commission has argued, is that the overall standard test is the test that the court used in the Tadic case, and Henry mentioned that, but in that context, it was the issue of concern and responsibility for violation of international humanitarian law. not of state responsibility. Anyhow, the bottom line is that there is an ongoing debate between effective control and overall control. But if we're to use the effective control test, at least from the evidence that I have seen, it seems that it's difficult to make an overarching statement that they are under Russian control until we have more evidence what exactly role have the Russian Defense Ministry, for example, played in specific military operations that resulted, of course, in atrocities. Was the Wagner Group operating under the instructions of, let's say, the Russian Defense Ministry, or they were acting as a fairly autonomous force? Because it seems in some conflict situations, some operations, they took the lead, the Wagner Group. In others, they coordinated more with Russian defense forces. So it is something, a judgment that needs to be made on a case-by-case basis, if, of course, ever this sees the light of Accountability Day. Now, concerning the accountability for violations for international humanitarian law.
George,
Yes.
time.
Okay. All right. So basically, I wanted to say something about that, but Kathy gives me the message that my time is up. So I will be happy to elaborate further on accountability for violations of international humanitarian law versus state responsibility for the actions of Wagner Group, if it is necessary during Q&A. So I would only briefly conclude by saying that the state responsibility issue actually is very critical here, because it is the issue that will establish basically the official nature, the official character of the Wagner group's acts in the battlefield. So this is a very important issue. And I stop here. Thank you.
Thank you, Dr. Andropoulos. If we have time, we will get back to you to give you extra time at the end. And that reminds me, it's a good segue. Everybody, please enter your questions in the chat box, and I will aggregate those and we can ask them as soon as Dr. Davis finishes. Our next speaker is Dr. Davis, who will cover some of the available international and hybrid mechanisms under international law with regard to Ukraine, including the current ICC indictment, as well as challenges in prosecuting atrocities at the ICC. And we'll touch upon the ICJ request, the discussion of a hybrid tribunal approved by Germany, and UNSC challenges due to Russia's member as a Security Council. Dr. Davis.
All right, great. Thank you for inviting me. And I'm turning on a timer, so I'm going to try really hard to stick to my 10-minute window here. So obviously, one of the biggest things that we're going to be talking about in this particular section of the debate is the unique status that we face with Russia as a UN Security Council member. As you know, brought up by some of the other speakers, this is something that's come up with US actions in other places, not to make an equivalency by any standard. But anytime a UN Security Council member is involved in any allegation or incident, obviously that complicates a lot of the international legal justice mechanisms. So while we have a series of domestic, hybrid, and international tribunals for international criminal accountability in terms of war crimes as well as crimes against humanity, Russia's unique position as that UNSC member limits many of these options, which really makes accountability a lot more challenging than it might be in some other cases. All cases are always challenging, but that makes it especially difficult. So I'm going to briefly walk through some of these options and then evaluate where accountability is likely to head for atrocities perpetrated in the Russia-Ukraine war. One of the first mechanisms available to states in both in terms of protecting civilian populations and also seeking international criminal liability are those embedded under Chapter 7 of the UN Charter. Chapter 7 allows the Council to determine the existence of any threat to the peace, breach of the peace, or act of aggression, and to take military and non-military action to restore international peace and security. The challenge there is that Chapter 7 can really only be authorized by the United Nations Security Council under Articles 41 and 42, respectively. And so that obviously is the first impediment. A lot of the cases that we've seen in the past, for instance, when international criminal tribunals were established for both the former Yugoslavia and Rwanda, those were done under Chapter 7. And without the ability to get Chapter 7 support by the UN Security Council, that does somewhat limit the options under Chapter 7 itself. So probably very unlikely to think that we might see any kind of pursuit under Article 39, under Articles 41 and 42 towards the aggression issue under Chapter 7 due to Russia's stance. They were the successor state to the USSR and are likely to veto any member, any efforts. We also don't know whether China usually abstains, but depending on how the relationship proceeds, we might see a different outcome. So another mechanism that can be applied and has been applied is the International Court of Justice. Though these opinions and decisions are largely considered advisory, they have no direct enforcement mechanism outside of referring it to the UN Security Council, which again falls under the prior situation. So the ICJ has heard cases involving Russia and Ukraine, specifically titled Allegations of Genocide under the Convention on the Prevention and Punishment of the Crime of Genocide, Ukraine versus the Russian Federation. That was brought by Ukraine to the International Court of Justice on February 26, 2022, just a couple days after the initial invasion itself. Ukraine asserted violations on aggression as well as genocide by Russia. Russia countered that they were acting on behalf of alleged genocide in Luhansk and Donetsk oblasts by Ukraine itself. The court found on 16th March 2022 with a sound majority of 13 votes and I believe 2 abstentions that there was sufficient evidence for Ukraine to invoke the compromissory clause under Article 9 of the Convention, which does give jurisdiction to the ICJ for disputes arising under this. They have a prior hearing from the earlier 2014 incidents, some noteworthy arguments of the court to support its preliminary decision following discharging its duty to prevent genocide. The court's possession of evidence substantiating genocide allegations and not seeing evidence supporting Russia's allegations. And the court also remains doubtful that the convention authorizes unilateral use of force in the territory of another state. But again, as much as they can produce these decisions and these advisory opinions without enforcement mechanism, they're very limited in what they can do, which is what created the need for the International Criminal Court in the first place. There was a move back in the late 1990s to create some sort of international criminal court following on the heels of the ICTR and the ICTY, which were both created under UNSC resolutions, to create something that had more both individual criminal liability as well as more teeth, if you will, more ability to have enforcement to findings. So International Criminal Court came into effect in 2002, as I'm sure many people are aware. So they also have investigated and taken a ability to investigate the situation in Ukraine. And what's interesting here is that neither Ukraine nor Russia are state parties to the Rome Convention, but Ukraine did pass a law allowing to request the ICC's investigation, which states can do even if they're not state parties. They can invite the ICC to investigate and create a situation in that country, which is what Ukraine did. Twice they have done so. They did so initially in under actions from November 21st, 2013 to 22 February 2014, and then the second declaration extended that time period on an open-ended basis, which proceeds from 20 February 2014 onwards to the present era. So on 28 February 2022, the ICC prosecutor Khan announced he would seek authorization to open an investigation into the situation in Ukraine on the basis of the office's earlier conclusions and the invitation from Ukraine. On March 1st, the Office of the Prosecutor received a state party referral on behalf of the Republic of Lithuania, which is a state party. On March 2nd, a coordinated group of over 40 states jointly submitted a joint referral. And on March 2nd, the prosecutor announced he had initiated proceedings to open investigation on the basis of those referrals. So the big event there is on March 17th, 2023. I will always remember that date because the arrest warrants were issued about 2 hours before I was presenting on this topic at ISA. So I was frantically updating my presentation as news was breaking and my cell phone was exploding more or less with updates. So on 17 March, the ICC pretrial Chamber 2 issued arrest warrants for 2 individuals, Vladimir Vladimirovich Putin, obviously president of the Russian Federation, and Maria Lvova-Belova, the commissioner for children's rights in the office of the president of the Russian Federation. Now, these are the only 2 arrest warrants that have been released to date. I know many legal scholars expect that other arrest warrants will be forthcoming. It is also possible that there are other arrest warrants, but those are still under seal. These are the only 2 right now that we have publicly available information that were actually released and unsealed by the court. So I do want to emphasize that that doesn't mean these are the only charges that we will see. These are the only ones so far that have been unsealed. So we don't know what we don't know, as they say. The specific 2 charges were reasonable grounds to believe each suspect bears responsibility for the war crimes of unlawful deportation of population children and unlawful transfer of population children from occupied areas of Ukraine to the Russian Federation. So those basically are concerning the filtration efforts and forcible transfer and adoption of Ukrainian children in Russia without consent of the children or authorized guardians of these children, parents, grandparents, otherwise. So what's really interesting, of course, here is that this is only, I believe, the 3rd time the ICC has gone after a sitting head of state. They did so twice previously. Former president of Sudan, Omar al-Bashir, in 2009 over allegations of genocide and crimes against humanity in Darfur. And then former Libyan president Muammar Gaddafi in 2011. That was probably the shortest one because he died just a couple months later. So that was withdrawn. But I think, and I'm going to wrap up on these notes because I do see I'm getting very short on time. The real interesting thing here is what does the international community do with Putin and Lvova-Belova regarding these charges? So this already came up once before, interestingly enough, with South Africa. That is, how do I turn this off? So what's interesting is that South Africa once before had al-Bashir travel to South Africa in 2015, and they did not surrender him to the ICC. Even though South Africa is a state party at the time, their statement was that they felt that they would be violating head of state immunity as their justification for not surrendering al-Bashir to the ICC. They were ultimately found by the ICC guilty of obstructing justice. Why is this relevant? Because in August 2023, South Africa will be hosting the BRICS summit for the BRICS member states, which does, in fact, of course, include Russia, among other state parties. In the past, Putin himself has traveled to BRICS conferences. And so this creates almost the exact same scenario that we had in 2015, where there may be a indicted alleged war criminal traveling to South Africa once again. And what does South Africa do? So far, the only statement they have said is that they are aware of their obligations under the Rome Convention and the International Criminal Court, and they are mindful of them, and that they are in contact with various relevant stakeholders. So I guess we'll find out what that means in August. And so I think the big takeaway here is, what does this mean for international criminal justice? What does this mean for international criminal liability, given that you may be seeing once again, an indicted sitting head of state choosing to travel or not travel, and given the status and stature of Russia in the international community, there is a lot of travel, including potentially here to the United States, New York City, where they had UN meetings. So what is going to happen in the future? Does Putin in particular stay in Russia to avoid being taken into custody by a member state? Or does he seek to call the bluff, if you will, not to say that it is a bluff, but put the United States in particular in a position where he or Maria Lvova-Belova travels to New York and then puts the United States on the position of choosing, do they surrender? Do they not? What do they do? And with that, I will conclude my remarks. Thank you very much. And I look forward to your questions.
Thank you, Dr. Davis. And at this point, we can turn to, we have about approximately 10 minutes, 11 minutes, where we can address some questions. Although there are no questions in the chat box at this time, please do enter your questions in the chat box. We would appreciate that. In the meantime, is there any panelist? I think Dr. Andropoulos, you wanted to make some final comments. Maybe we can wrap back to you for a few minutes. Dr. Andropoulos?
I'll be happy to, but shall we first wait to see if, before we get to the wrap-up comments, whether any if we don't get any questions in the chat room, whether any of the panelists have some follow-up thoughts after the presentations, and then we can wrap up if we don't have any questions. I have some comments I'd like to make, but I would like first to give the floor to other colleagues if they have any follow-up comments or thoughts, either things they wanted to say that they did not get a chance to say because they ran out of time, or in response to a comment that one of our fellow panelists made. Shall we?
Any of the panelists want to make a comment?
Anybody has any thoughts?
Looks like Dr.
comments?
Carey does. Dr. Carey?
Well, I just unmuted myself, but I would just like to make one quick comment, which is that the potential for implementing these laws, we should think, I would argue, more broadly than just prosecution. I mean, that's the most dramatic form of accountability, but there are lots of other forms of accountability that matter, that in the long run, the longue durée, as they say in French, it's going to strengthen and legalize further the various jus ad bellum and jus un bello crimes that have been mentioned. But we also have the whole range of illegal acts that are non-criminal, that are forms of accountability. And we have the investigations, which will have some kind of historical record that's not irrelevant either. So that becomes a glass half full, half empty. You can say no prosecutions law doesn't exist. From my viewpoint, almost every important international law, including the ones we've mentioned today, are probably more characterized by non-implementation, but it's not irrelevant that illegal acts have been identified clearly. And for example, on the one hand, in the era of the Iraq War, the torture that was authorized by the US administration was made legal, and there's only been one extraterritorial prosecution of torture in US history under that federal statute. But it's universally accepted that torture occurred, and all of the habeas corpus litigation that went to the Supreme Court of the United States was made on behalf of enhancing the rule of law. So there are lots of ways this could evolve, even given the tendency towards multipolar world that is eroding some of the structural foundations of international law.
Thank you, Dr. Carey. And we have a question from one of the participants. So what happens if you leave an organization like the ICC? Does leaving for the purpose of leaving an agreement or court matter compared to leaving for other reasons?
Well, the US withdrew in the Nicaragua case before the ICJ, and they still proceeded and held the US liable for various violations of international law. That's a different court, and perhaps it would be different in a criminal type of trial. I would only add further that customary international law on a particular substantive matter would rule even if someone became a non-state party by withdrawing from the ICC.
Yeah, I mean, I think specific to the ICC, there's a couple different things. Is that there is a process by which you do have to formally de-ratify and withdraw. It's not just enough to say we're not honoring it anymore. There is a process by which you have to go through. But I mean, ultimately, I don't, like with any legal agreement or treaty, I don't think your motivation for doing so has any recourse. If you withdraw from a treaty and renounce your obligations, then the reason why is less relevant. So I don't, that would be my take. I certainly defer to others, but I don't know. I mean, I think diplomatically and politically it might have implications, but legally, I'm not sure.
Mhm.
George.
Dr. Lovett and then Dr.
Oh,
Andropoulos.
sorry. Yeah.
Yes, sorry.
Yeah.
No, I just to agree, and there's precedent for this as well, right? From Burundi and from the Philippines. It's a bit like Hotel California. You know, you can check in, but you're kind of stuck with whatever's happened while you're there. You can try to leave, but legally, good luck. Now, of course, that the implication is yes, the court can nominally keep trying to investigate, but if it has no way of actually conducting the investigation, it's not going to get very far, right? So the practical hurdles that can be thrown up by withdrawal can be quite significant, notwithstanding the formal legal, let's say, lack of implications.
Dr.
Yeah,
Andropoulos.
I think I agree with you, Jen. Right? That's basically what you just said. Right. Just checking.
Yeah. Just basically to reconfirm one point that has already been made, it doesn't matter the reasons that you leave an organization, you leave it and then obviously you are not under its jurisdiction. The interesting question comes, what's going to happen if there is already a pending case against you? And of course, this depends from court to court. For example, the European Court of Human Rights, speaking about in the case of Russia, as you are aware, okay, Russia was never a member of the ICC, so that's not an issue as far as Russia. But Russia was a member of the Council of Europe and the European the Convention on the European Convention on Human Rights and Fundamental Freedom, which makes it subject to the jurisdiction of the European Court of Human Rights. Formally, as you know, Russia has severed its ties with the European Convention and the court in the fall of 2022. Okay, it was a transitional period. So after the Council of Europe voted to was moving in the direction of kicking, Russia out the Council of Europe. Russia left the Council of Europe and is not subjected to the jurisdiction of the court. I don't remember the exact dates, but it's either September or October 2022. Now, however, there are cases that are pending before the European Court of Human Rights against Russia. This will continue. And in fact, they do not relate with the war in Ukraine. There are other issues. But this will continue, and we're talking about a huge number of cases, petitions that are still on the pipeline against. Now, of course, what will Russia do, even if the European Court of Human Rights proceeds with these cases and issues rulings against Russia? And of course, as you all know, the European Court of Human Rights does not have criminal jurisdiction. It is civil. I suspect that Russia will ignore the decisions. However, decisions will be issued.
Okay, we have no other questions and we have 2 minutes left in our presentation. Does anybody want to make
There is another question from Matthew Colasso.
Oh, okay, I just saw it. Why is control of the Wagner Group so important? And why is it unclear? Is hybrid war new?
Well, mercenaries and paramilitaries have been used since time immemorial, so it's not a new phenomenon. The fact that it's legalized is relatively new, but the UN has also been involved in clarifying the prohibition of mercenaries, and George has already discussed that.
Dr. Lovat?
So this goes back to the sort of the central issue of competent status, Matthew, everybody. And what many of the huge debates around the distinction between NIAC and IAC over the design of the Geneva Convention regime go to, well, who's a competent? If you're a competent, you have competent privilege. That means you can do stuff like kill people, which would otherwise be unlawful, right? So if you are a lawful competent or have competent privilege in a war, you can kill people. You can also get killed, but you can shoot people and you're not committing a crime in doing that. If you do not have competent privilege, then you are not entitled to that benefit, nor are you entitled to POW status if you are captured. And that is the main implication of whether mercenaries, the Wagner Group, whoever, are entitled to that particular status. That's why this matters. If you use non-state, non-sanctioned, competent, non-sanctioned armed groups, what is their status? If you capture them, how do they have to be treated? If they shoot somebody, what are the implications of that for them and their accountability? Are they entitled to competent privilege, in which case you put them in a POW camp, thank you very much? Or have they committed essentially murder, an unsanctioned crime and subject to normal sort of domestic law? And that's why it matters.
Yeah, may I add? Yeah.
Is that a narrow legal answer? Sorry.
Yeah, may I add to what actually Chip and Henry said? Control is important, Matthew, because, and the combatant issue, because it is not only the issue of individual criminal responsibility, and as it was pointed out, if you are combatant means at least you can take up arms and fight and kill, and you cannot be prosecuted for that, for participating in hostilities. The only thing you can be prosecuted is in the conduct of hostilities if your behavior violates the laws and customs of war. But control is also very important because we should not, when we think about accountability, we should not only be thinking in accountability in terms of individual criminal responsibility, we should also be thinking about state responsibility for violations. So the question of whether Russia controls the activities of Wagner Group will be very important if you want to establish at the non-criminal justice level Russia's responsibility for the activities for the purpose, for example, of attribution. And if you can attribute responsibility, then in a proceeding, in a non-criminal proceeding, Russia may be liable for reparations for the activities of the Wagner Group. So have in mind, when we talk about accountability, one level is the individual accountability, which is associated, of course, with prosecution. But the other is state responsibility for the activities of its armed forces that entail international responsibility for the commission of internationally wrongful acts. That's where the articles on state responsibility that have been drafted and have been laying there waiting for an official codification by the International Law Commission. One other very quick thing I want to add about the mercenaries that I did not mention in my presentation. It is important to bear in mind that the mercenary, the way it is phrased, if you look at Article 47, and this relates to those actually those fighters of Wagner that do not qualify as regular combatants, because, for example, they are not of the nationality of Russia or any other party of the conflict, and they are paid higher, gets actually a higher payment than regular soldiers will do, and the other criteria for identifying a mercenary. The mercenaries do not have the right to be a combatant or prisoner of war, but this does not mean a state that holds them cannot give them that status. It is the mercenaries do not have a right to demand that be treated as combatants, but the states that hold them in its jurisdiction may decide at its discretion to give them combatant status. And there was a big debate when the additional protocol 1 was drafted, how to phrase exactly that particular issue, because there were some states, especially from the global south, that they say that not only the mercenaries have no right to be a combatant or a prisoner of war, but the state also under whose jurisdiction they may be has an obligation not to grant them that status. And that actually was not included finally in the final draft of the additional protocol.
George, how about vice versa, foreign citizens fighting on the side of Ukraine? What would be their status there?
What?
Well, there is an opposite situation too. There are lots of citizens of third countries fighting in Ukraine on the side of Ukraine.
Yeah.
Same situation.
Yeah. Well, the thing is that, listen, if they are non-citizens, they may be considered as mercenaries, but the question is, do they qualify as mercenaries in accordance actually with the article, I mean, the conditions that AP1 sets for the definition of mercenary, okay? Because to be the qualification to be a citizen of a country, sorry, not to be a citizen of a party to the conflict is one of the attributes in order to get the label of mercenary, but there are others, okay? So you have to look at it on a case-by-case basis. But the answer to your question is that in a nutshell is, if somebody is fighting on the side of Ukrainian forces and is a non-citizen of Ukraine, you have to be you have to be fighting though. Consultants, or if you offer other services, do not come under the rubric of a mercenary. You must be fighting in order to be considered. You can be a mercenary if you fulfill also the other requirements. So, but this can only be decided on a case-by-case basis, because there may be some people that qualify to have the mercenary label, and some others may not. But clearly, not being a citizen of Ukraine, not being a citizen of Russia, opens you up to the possibility of being considered a mercenary, being classified as mercenary, provided also the other requirements of additional protocol 1 are fulfilled.
Okay, and with that, we are very well past our time right now. So we do need to wrap up. I want to take this opportunity to thank our participants, and more importantly, to thank each of our panelists, wonderful comments and a wonderful panel altogether. And I want to thank ISA for helping us host this, in particular for Sarah providing us technical support. So everybody, thank you very much. Thank you for attending, for participating, and hopefully we'll have more of these in the future. Good day.
And I'm sure we'd all like to thank Kathy as well for her
Yes.
excellent moderation.
Yes, thank you very much, Kathy, to all the participants today, the panelists, and of course to Sarah and the staff at ISA. Thank you very much.
Agreed.
Yeah. Have we stopped the recording?
Thank you all.
Thank you.